Good morning, good afternoon, and good evening, dear speakers and participants of today's webinar. Warm welcome on behalf of the whole ERRA Secretariat team. My name is Kacper Jarosz. I'm a project manager at the ERRA Secretariat, and it is my pleasure to welcome you and to open today's webinar on energy market surveillance, fundamentals of enforcement and abusive practices. We have a great roster of experts today to present the findings of ERRA survey, to present the expertise, many years of expertise related to market surveillance and market monitoring. First of all, before we start, it is my role today to provide a little bit of introduction to what ERRA is, also to present the housekeeping rules and introduce you to the agenda of today's event. I will start with the introduction of ERRA. We are an Energy Regulators Regional Association comprising 48 members currently from all over the world, as presented in the map. And our interinstitutional framework focuses on bringing together effective energy regulators with the necessary autonomy and authority to make positive change. We have been operating for 20 years. Last year we had our 20th anniversary. And we focus in our public activities on three main work streams. These are the online trainings that are currently provided through an e-learning platform. We also organize webinars such as this one, and we provide data services based on our online tariff database. But our work does not focus only there. We invite you to visit our website and see our other public activities that are open to the wide range of energy professionals. Coming to the housekeeping rules of today, please note that all participants are muted for the duration of the webinar. If you have questions to any of the presentations, please type them in the chat window of Zoom, and these will be later read by the moderator and conveyed to the speakers. In case your questions remain unanswered, for example, because of time constraints, we will be addressing them via email after the event, so please don't worry, your inquiries will not remain unanswered in the long run. For technical inquiries, please write to secretariat@erranet.org. We provide background support in case there will be such need. Before I wish you a pleasant and insightful webinar, please let me also convey our acknowledgements to the Hungarian Energy and Public Utility Authority, which made this webinar available for the public. Now, let me quickly run through the agenda. This will be further elaborated on by our moderator today, but I will just quickly browse through the main points of today's program. First of all, in the first part of our meeting, we will have opening remarks and introduction of findings of the ERRA survey by our today's moderator, Mr. Mariusz Swora, who is a member of ACER's Board of Appeal, also a member of ERRA Strategic Advisory Board member, also former ERRA Vice Chair, and also a former chairman of Polish Regulatory Authority for Energy. Then we will move on to the market surveillance and regulatory powers session, which will comprise of three presentations. Two of them will be presented by two excellent experts from ACER, for the Agency for the Cooperation of Energy Regulators. And the third presentation will be given by three key experts from the Federal Energy Regulatory Commission from the United States. Then we will have a short technical break to have a little rest, have a coffee. And after the break, we will focus on the case studies, the types of abusive practices. And the case studies will be preceded by a presentation on types of market manipulation in energy markets. And then the case studies itself by another three excellent speakers, which we hope to hear very soon, and the whole webinar will be concluded with a panel discussion moderated by Mr. Swora. I believe we are done with the introduction to the webinar. Thank you very much for your attention. And now I would like to invite Mr. Mariusz Swora, our moderator today, to take the lead and to start with his presentation. Thank you very much. And please, Mr. Swora, the floor is yours.
Hello, everyone, and welcome to today's webinar. Kacper, thank you very much for your introduction. First of all, I got a feeling that with today's session, ERRA opens new chapter in its history related to capacity building in the area of market surveillance and enforcement of market abuses by energy regulators. First of all, I would like to warmly welcome all our eminent speakers who will share their unique knowledge, and participants who decided to join us today. I would like also to show my gratitude to three very important institutions that gave us their intellectual and financial support, namely FERC, ACER, and Hungarian regulator as a sponsor of the event. My special thanks to the Secretariat for their help and their assistance in the preparation of today's webinar. Can we move to the next slide, please? In the beginning, I would like to present you the goals of this webinar and ERRA involvement in enforcement of market manipulations in general. So we address this webinar both to regulators and market players. ERRA would like to help regulators in building capacity in market surveillance and enforcement of market abuses. ERRA is also ready to assist in the development of market surveillance systems and or improving the existing ones. In the case of market players, ERRA would like to contribute to better understanding the need for efficient market surveillance and gaining acceptance by market players. We believe also that through the participation in these webinars, market players will be able to develop or improve their compliance programs. As it always happens before launching new program within ERRA, we surveyed regulators about asking them about law and practice in their jurisdiction to better understand their needs. Thereby, I'd like to thank all regulators. Can we move to the next slide, please, to show all the regulators who participated in the survey? Okay, thank you. Thereby, I'd like to thank all the regulators that participated in our survey. Now I'd like to go briefly, just not to steal the time from our speakers. I'd like to go briefly through main results, just announcing that the survey, together with our interpretation, will be available on our website late July. Can we move to the next slide, please? Thank you very much. So first, we asked ERRA regulators whether there are special laws prohibiting market manipulations in their jurisdictions. Most of them answered that there are such laws already in force or under preparation. It's worth mentioning that alternatively, manipulations on energy markets may be covered by general laws prohibiting market manipulations. In the European Union, for example, there are directly applicable norms of EU, which are supplemented by national regulations. Can we move to the next slide, please? We asked ERRA regulators which authority is responsible for investigating market manipulations on energy markets. Most of them answered that energy regulators are responsible for investigating, sharing sometimes their functions with competition authorities or financial supervisors. Can we move to the next slide, please? Similar answers have been given as regards penalizing market manipulations. It is worth mentioning that the competence to penalize market manipulation may be split between energy market regulators and other institutions like courts. This is the situation, for example, in Poland, where the regulator has investigative powers and the courts have powers to put sanctions. I would say from the Polish perspective that this is not very efficient solution. Can we move to the next slide, please? Apart from asking regulators about the status quo, we have also asked them about their views on the regulatory powers in enforcement of market manipulations. Most of them answered that energy regulators should have powers both to investigate and penalize market manipulations. Only 2 regulators answered that regulators should only cooperate with other authorities, helping them to fulfill their functions. And the last slide, please. Can you put the last slide? Yes, thank you very much. Last but not least, we asked about the future role of ERRA as regards the enforcement of market manipulation. What is interesting and even striking for me is that regulators see the role of ERRA not only in training, but also in providing guidelines and best practices, as well as enabling cooperation between regulators. This is really valuable food for thought for us for the future. And in the end, let me share with you a few bullets for the conclusion. Can you move to the very last slide? Thank you. So first, market manipulations can be enforced by various institutional actors like regulators, financial supervisors, competition authorities. Second, energy markets are complex, and these may justify empowering energy regulators to investigate penalize market abuses and impose penalties. Thirdly, most of surveyed ERRA regulators point out imposing penalties and or investigating in market surveillance as possible or desired regulatory task. Therefore, we conclude that there is a need for the enhancement of ERRA regulators' capacities in market surveillance. That was our survey in brief. Thank you very much. And now we are starting first session of today's seminars on market. The first session is a kind of institutional one devoted to market surveillance and regulatory powers. I'd like to give the floor now to Dr. Eleonora NAGALI, who is a policy officer at the Agency for the Cooperation of Energy Regulators. Eleonora is going to tell us about the heart of the European system of energy market surveillance, which is data collection. Eleonora, the floor is yours.
Thank you very much. Thank you. And first of all, I would like to thank also the organizer from ERRA for inviting us, me and Daniel from ACER. As ACER, we are really happy to share our experience with you today and our best practices. So now let me just share my screen. So you can, do you see my presentation?
Yes, we do.
Okay, perfect. Okay, yes. So indeed, my name is Eleonora NAGALI, and I'm a policy officer in the Market Integrity and Transparency Department at ACER. That is one of the two departments that is in charge of dealing with REMIT tasks. In particular, I'm in charge of providing guidance on transaction reporting, so on the guidance to the stakeholders on how to collect and report data to ACER. Okay, first of all, the first slide just start with a brief introduction on ACER. So ACER is the European Union Agency for the Cooperation of Energy Regulators that was established in the third energy package and in 2010 and was settled in Ljubljana, so in the beautiful city of Ljubljana in Slovenia in 2011. We are now more than 100 people in ACER dealing with different tasks and coming from all over Europe, which is one of the major strengths, I would say, of our agency. The main purpose of the agency, as highlighted also in the ACER regulation that was recently renewed, let's say, by the Clean Energy Package, is to assist the national regulatory authority in exercising at union level the regulatory tasks performed in the member state and where necessary to coordinate direction. Indeed, the name of the agency is European Agency for the Cooperation. So our main task is to support the NRAs in their cooperation in order to fulfill their mandate, but also we as an agency have some tasks assigned directly to ACER, in particular when dealing with cross-border issues. If we look at REMIT regulation, so the regulation that was established in 2011, there is one specific task that is quite relevant for the webinar today, that is described in Article 7. Such task is that the agency shall monitor the trading activity in the wholesale energy products to detect and prevent trading based on inside information and market manipulation, so shall prevent the market abuse. It shall collect the data for assessing and monitoring wholesale energy markets as provided for the Article 8. So in Article 8, there is the description of the data collection process, but already in Article 7, there is the clear description of the task of the agency. So the agency shall monitor the trading behavior on the energy market, on the wholesale energy market in Europe. And in order to carry out such activity, what is fundamental for the agency is to being able to collect the data on the trading activity, which is somehow the building block of the surveillance activity carried out in ACER. Indeed, if we now refer to the tasks that are described in the REMIT regulation, we can identify 4 different main activities. First of all, we have the creation and the management of a European register, a centralized register of all the market participants that are active in Europe. So this means that we also include non-European market participants as long as they are active in the European wholesale energy market. Then we have the main activity of data collection, so collecting the data on the trading activity on the wholesale energy market, and also share such information with the national regulatory authority. Indeed, the third main activity is the cooperation and coordination with the stakeholders and with the national regulatory authority that receive this data and also are in charge of dealing with the monitoring activity of their relevant market. And finally, we have the market monitoring and the surveillance. So these 4 activities in ACER are carried out by 2 different departments. one department, that is the one to which I belong, the Market Integrity and Transparency, is in charge of dealing with the European Register of the Market Participant and the data collection and data sharing. So the main activities is collecting the data, providing guidance to the market participant and to the stakeholders on how to report this data to the agency, and of course ensure cooperation and coordination, which is a common task with the second department, that is the Market Surveillance and Conduct Department. On the activity carried out on market surveillance, then there will be the presentation of Daniel following this one, that will report all the details on how we carried out this activity in the Market Surveillance Department, and how also we manage our cooperation and coordination with the NRAs, which I believe will be interesting in relation also to the outcome of the survey that were presented a few minutes ago. Here we represent, let's say, a picture, a screenshot of the situation of our activities, so data collection and market surveillance in 2020. Of course, now the situation is slightly different because of Brexit. So the UK is no longer under the monitoring activity and the data collection under REMIT. So we deal now with 28 NRAs. But still, you can see how advanced somehow our activity is since the data collection started in 2015. So we started in 2015, and now we reached more than 2 billion of records collected per year. We'll go in detail later on. The European register includes more than 15,000 of market participants. And then we have also all the details of the activity of the market surveillance, considering the alerts, the suspicious transactions, which is quite an intensive, let's say, activity that we are dealing, that we are carrying out in our two departments. Of course, I was referring before to the need to ensure a proper cooperation with the regulators, because we share the data. Whenever there is a suspicious case, also we have to coordinate with them. But it's also fundamental to ensure a proper coordination and cooperation also with our stakeholders. We have different types of stakeholders. So we have the market participants, the transmission system operators, the organized marketplace, and we manage this kind of cooperation via a dedicated portal, that is the REMIT portal. Is a public open website that is accessible to everybody. And in the REMIT portal, we provide all the information with reference to the European register, the list of the organized marketplace that offer wholesale energy products in Europe, the list of all the contracts that are considered standard, so that are offered by the organized marketplace and should be reported to ACER, the list of the RRM we will see in detail in few slides, so the entities that report the data to ACER, plus all the documents and information also from the IT point of view on the functioning of our IT system that is aimed at collecting the data. Now, as also reported in the title of the presentation, I will provide an overview and a focus on the data collection, how we carried out the data collection in the Market Integrity and Transparency Department in ACER. The core of the data collection is described in Article 8 of REMIT and impose on the market participant the obligation to report trades and order to trades placed on the wholesale energy market in Europe to ACER. So now we have more than 15,000 market participants that have to report to ACER, not only the transactions concluded on the market, which is a feature of the financial regulation, for example, but in REMIT, we also collect the orders to trade that are placed on the organized marketplace, as well to the bilateral contracts that are concluded with reference to the supply or to the transportation of the electricity and natural gas with delivery in the Union, in the European Union. Such information can be reported to ACER only via some selected entities that have to be registered in a dedicated list of ACER. And these entities are known as Register Reporting Mechanism, or RRM. The RRM have to comply with a set of requirements, IT requirements, security requirements, technical requirements in general. And in order, let's say, to optimize also the data collection process. So we, as ACER, we do not deal directly with the market participants, but for the data collection, we only deal with the RRM that are now, this is the latest data available at the end of the first quarter of 2021, were 108. So we simplified a little bit the process, dealing only with 100 entities instead of more than thousands. Together with the collection of the data on the trades, the bilateral contracts, and the order to trades on the market, we also collect information on the inside information. Because in REMIT, again, there is the prohibition to carry out insider trading, so to use the inside information in order to trade. And as ACER, we provided indication to the market participant to refer to inside information platforms, so dedicated platforms that offer an effective way to disclose a potential inside information, so an information that might affect the price of the market. And within the data collection process, we also collect from the IIPs that are listed in our public list of the inside information platform, the information published on their platform via web feed. If we look at the hierarchy of the REMIT rules, we can see that we have, first of all, the first level of our activities is designed by the REMIT regulation. This is, of course, the first level. Then we have the implementing acts, so the implementing regulation of REMIT that defines and provides details on how to carry out the data collection process and the data reporting. Recently, in January 2021, entered into force also an additional decision of the European Commission that allows ACER to collect fees from the reporting parties based on the reported data. And this is aimed at supporting our activity of data collection and market surveillance. And finally, we get to the third level of documents. That is the one to which we mainly refer in our everyday activity as ACER. The third level is composed by guidance that we as ACER manage directly. So we created in 2015 some guidance to the stakeholders. As you can see, the requirements that have to be fulfilled by the RRM. The technical specification, this is not a public document, but it's a document that provides the specific technical specification that have to be implemented by the RRMs. And then we have the transaction reporting user manual, that is a huge document where we included information on the transaction reporting. And likely we have a similar document on the fundamental data reporting, so on additional data that we collect from the market participant. These four documents are directly managed by ACER and are updated on a periodic basis. All the documents, except from the technical specification to the RRMs, are public and available on the REMIT portal. So on the REMIT portal, under the section documents, you can find also our documents and guidance to the stakeholder. And together with those four, we complemented these main documents with additional 3 documents that are the Q&A, the question and answer on the REMIT applicability and the REMIT application. So general questions on the policy. And then more technical and operational questions, I have to say, on transaction reporting and on the disclosure on inside information and how to report fundamental data to ACER. This kind of question have been included in 2 dedicated documents that are the FAQs of REMIT. So all the 3 documents are public also on the REMIT portal. What I would like here to highlight, and this is why also is really important, our relation with the stakeholders, is that according to the Implementing Act, we have to consult our guidance with the stakeholders. So before updating a document and publishing on the REMIT portal, we always carried out a consultation with all our relevant stakeholders. Just providing you a little bit of information on the different documents. So on the third level, as I was indicating, the RRM requirements include the list of all the requirements that are expected to be fulfilled by the RRM. And then additional details from the IT point of view are provided to the RRM only when the RRM starts the registration process. That is a 2-3 months period process, no? That the RRM has to face in order to be listed in our list of the RRM. Then we have the manual of procedure on transaction and fundamental data reporting. So this is mainly an operational document that provides explanation on the IT format of the files that have to be reported to ACER under the data reporting obligation. And then finally, we have exactly the TRAM, the Transaction Reporting User Manual, that reports all the explanation and all the details of all the fields that have to be reported to ACER. Just imagine that when we deal with supply contracts, for example, of a contract that is concluded on an organized marketplace, we expect the market participant and then the RRM to report 58 fields to us. So for each field, the TRAM provides an explanation, an indication of how to populate this field. There are several values that are allowed. So in order to choose which value we would expect to be reported for a specific transaction, all this information, all this guidance is provided via the TRAM. The TRAM has 7 annexes, so it's becoming bigger and bigger, I have to say, in years, because of course the complexity of the market increased. So we, I would say, on a yearly basis, provide an update of this document in order to be in line with the evolution of the market. On this slide, I wanted to report the trend of the data that we collect. As I was saying before, we started to collect data in October 2015. So this is why also here the histogram is a little bit tiny, because in the end, this considers only the last quarter of 2015. But then starting from 2016, what we have been observed is a great and exponential increasing of the data that we collected. And in 2020, we concluded the year with more than 2.4 billions of records collected. Here I refer to records including trades and order to trades. So of course, in order to being able to collect this amount of information, we had to settle a proper infrastructure from the IT point of view that is known as ARIS. Here I will not go into the detail of the structure of ARIS, but I just would like to provide you the flavor. So the first level, of course, of the machine is the reporting parties. So who reports the data is the RRM, and then for the transaction reporting, but then we also foresee the possibility for other entities like the ENSO-E, ENSO-G, so the association of the TSOs and its information platforms, the NRAs, to feed our database. The reporting parties provide the input, so the data, to our core ARIS system. So we have some validation rules at the entrance of the file. So we screen and we filter the data we collect based on some data validation that ensure a first level of check of the data quality, because in order to ensure to the colleagues of the market surveillance environment, it's fundamental to ensure a proper level of data quality. And then the information is stored in our main database. The data is also then sent and shared with other tiers, so other modules of our database that allow to our colleagues so the ACER users in ACER, to access to the REMIT data for their own purpose. So in particular, the ACER users for us are also the colleagues of the Market Surveillance Department that can access to the REMIT data. And also, we have a module dedicated to the data sharing. So the data sharing is the process that we use in order to share the data, the REMIT data, with the NRAs. So the NRAs can also access to our REMIT database with reference to the relevant data, so only the national data, of course. Now, just to conclude, I would like here to highlight the main challenges that I see for ACER in the upcoming years, hoping that this can be also the inspiration also for some of you. We have two types of challenges. One is, of course, taking care of the market evolution. The fact that the market is evolving, you know that in Europe we have market coupling, for example, that represents one of the main modification of the market, and this imposes some challenges to the REMIT data collection. Also, the adoption of algorithmic trading is inducing a great increasing of the data we are collecting. And also the challenges imposed by the EU Green Deal. So even if new commodities, for example, will be included in the data collection of REMIT, this will be a challenge for us in order to update our documentation and also being able to collect this new data. The second main driver is the REMIT role evolution. So this is, I would say, is somehow can be also independent a little bit from some of the challenges related to the market evolution, such as the improving of the data quality. We have a fair data quality. We also publish on a quarterly basis a REMIT quarterly on our REMIT portal, where we provide some indication of our activities and analysis on the data we collect, but still there is some work to do in order to fine-tune the data quality of our data and ensure a proper and efficient data surveillance, market surveillance. And then we would like also to try to induce an evolution of the REMIT data management in order to share this information also with other entities outside ACERs, like institutions for transparency purpose. So provided that we will anonymize the data, try to share even on a broader perimeter this information with other institutions in order to allow further studies and analysis. So yeah, this is it for my side. I would like to thank you for your time, and I hope everything was clear, but happy to reply to the questions when there will be the Q&A session.
Thank you very much, Eleonora. In fact, we have a question from the audience. This is a kind of question which is also very interesting from my point of view. As together, as I had the pleasure together with Piotr Suski, who is a speaker in the next session, we had the pleasure to assist British DSOs and DSO in evaluation of risks related to data exchange within a blockchain-based system, gathering information from distributed generation. So the question from the audience comes from Ireland, from Oliver Bredish, who asks as follows: has any consideration been given to expanding REMIT to future flexible service markets at the distribution level? This is a question from DSO in Ireland.
Mm-hmm. Yeah, thank you very much for the question. Indeed, I was referring in the slide on the challenges also of new actors, and indeed DSOs for sure are part of those new actors that are becoming more and more important on the wholesale energy market. So I do not exclude, let's say, that they will be included in our perimeter of for the data collection. Officially, this will be clarified with an official position of ACER in one of our public documents, likely also the Q&A document whenever this will be the case. So I do not exclude, I cannot confirm, let's say, that for the time being, for sure this will happen, but it's something that we are considering for sure.
Thank you very much for your answer. I see we have also thanks from Ireland, from OIFI. So I have one more short question, because ERRA consists not only of regulators from European Union. So I'd like to ask a kind of a general question. Can you imagine successful functioning of market surveillance without effective system of data collection?
Let's say from my point of view, will be weird to say no, to say yes, because I truly believe on the necessity of having a proper data collection. I've been working also in the surveillance in my previous experience, and I have to say the data collection and having a reliable data to which you can refer to is essential if you want to then being able to reach some reasonable and also strong conclusion, no, on a suspect. And this is why also we are working so much in ACER, and we're struggling in order to ensure a high data quality, because as long as our guidance, for example, are not clear enough to all the stakeholders, and there might be some misreporting, then becomes difficult for the colleagues of the surveillance to understand the data that they look at. So I believe that really, I'm strongly convinced on the fact that data collection is the building block of the market surveillance. So it's essential to have first a proper data collection system in place and then proceed with the market surveillance. So the collection on ad hoc basis maybe is not sufficient, might not be sufficient.
So let's conclude that the effective system of data collection is a sine qua non condition for effective system of market surveillance. Thank you very much, Eleonora.
Thank you
for this great presentation. And as the second speaker, we have Daniel Ichasztot, who is also policy officer at the Agency for the Cooperation of Energy Regulators, and he's going to present us some general thoughts on market abuse under REMIT. Daniel, the floor is yours.
Thank you, Mariusz. I beamed my presentation, so I hope it's there. I'm going to talk about market abuse. Thank you. From the perspective of REMIT, of course, which is the European regulation for wholesale energy market integrity and transparency, of course, as Eleonora also mentioned. And while she was focusing on the data collection, which is the basis for market surveillance, investigation, and enforcement, I will focus more on this latter section. I also have an introductory slide, though, with ACER, so I will not repeat what Eleonora said. Maybe just emphasize that this is an EU agency, and we work with the national regulators, the national energy regulators, which we refer to as NRAs, as in short, national regulatory authorities. So when you hear me saying NRAs, those are the regulators of the member states, and we are working with the regulators to foster the integration and competition of the European internal energy market. But in specific, in this case, it's about REMIT, which is of course part of this effort to create an internal energy market. So what is REMIT beyond the data collection? Well, it's an efficient oversight framework for the wholesale energy markets. And the ultimate aim is open and fair competition for the benefit of final consumers, which you see on the right on my screen. So working back from that goal, open and fair competition, we need the transparency and integrity. In particular, when we talk about transparency, REMIT sets obligations for market participants to disclose inside information and prohibits abusive practices. So we need those two elements for markets to work, and we have then the REMIT framework, which consists of data collection. Again, we talked about it, and then surveillance of the markets with this data, and investigation of anomalous behaviors, and then enforcement of the law. So going forward, how do we do it? Well, ACER, so the EU agency, and the NRAs, the national regulators, they split the task. Data collection and market surveillance is a centralized activity. It resides at ACER, so we do the EU-wide collection of data and the EU-wide monitoring of this data through specialized softwares and algorithms. We screen through the data, and when we see something anomalous, then a so-called alert is triggered. And we share those alerts, we share those anomalous instances with the NRAs then, who are responsible for the evidence collection if the situation merits further attention. So NRAs can request information from the companies. They can ask for electronic communication, emails, phone conversations. They can request traders to come for an interview, or they can even show up at the company on a given morning to have a thorough discussion with the company. So after investigation, the regulators, if the REMIT breach is proven, can levy a fine on the companies and enforce and change the decision, enforce the law. So this is how the task is split. Now on the white, you see that in the white boxes that data collection and surveillance can be done also on national level if the NRA opts for it. But in any case, ACER would do it because this is, firstly, it's our mandate, and secondly, it's also the efficient thing to do to collect data, then collect all data, and then do the surveillance on this EU-wide data. When it comes to investigation and enforcement, ACER is tasked with the coordination and consistency of the application of REMIT. And going forward from here, to ensure the coordinated and consistent application of REMIT, ACER publishes a guidance, which is just another document on top of all the things Eleonora has said. And in this guidance, we explain concepts of REMIT, what is a wholesale energy market, what is a wholesale energy product, and of course, what is market abuse. Then we also have so-called guidance notes that focus on particular behaviors. Layering and spoofing is one of them. Transmission capacity hoarding, wash trades are all specific behaviors that can be manipulative. So based on the guidance and the guidance notes, I will go a bit more in detail into what is market abuse, and I will give some examples. So what is market abuse? So market abuse is the the term for market manipulation and insider trading, so the commonly known as market abuse. We have in REMIT the concept of attempted market manipulation and market manipulation, which I understand is slightly different, for example, in the US. Now, the core element for attempted market manipulation is the intention behind the behavior, even if the attempt is unsuccessful. So if there is evidence for the intention, but the behavior eventually has no effect, it would still amount to attempted market manipulation. Whereas for market manipulation, the core element is the effect or the likely effect of the behavior, regardless of the intention behind, right? So with those two concepts, REMIT actually covers a wide spectrum, which of course helps NRAs to enforce REMIT. I will also add here, I think it's important to emphasize that whether there is whether the company reaped profit or benefit from the manipulative behavior, it doesn't influence the assessment of market manipulation or attempted market manipulation. Even without any benefit, the behavior can amount to those concepts. So from that perspective, even an erroneous trading activity that maybe even causes a loss to the market participant can be market manipulation. Again, so we are covering a wide basis here. And then we have insider trading, and for which I will go to the next slide. And for insider trading, we first need to understand what is inside information. So inside information is a piece of information that is precise. In other words, there is a realistic prospect that the effect will occur. So this precise information is not public, and it's related to one or more wholesale energy products. And if it is made public, then it is likely to significantly affect the prices of those wholesale energy products. So four cumulative criteria to assess when we talk about insider trading. So did the company possess inside information, and then whether this company or natural person use that inside information to trade or try to trade. That is one example for insider trading, but REMIT goes beyond, and also if the market participant discloses this information or recommends or induces another person to trade on the basis of this information, it all amounts to insider trading. So notice that only in the first category, the first type, does the market participant actually trade. In the two other categories, the market participant possessing this inside information doesn't trade, still covered under this is Article 3 of the regulation. And this is, of course, is forbidden under REMIT. So this is insider trading. I will go into the other type of market abuse, market manipulation. And REMIT provides four categories of market manipulation. So you shouldn't send false and misleading signals through your orders and or trades, or position the price at an artificial level, or use transactions involving fictitious devices and deception. So those are the first three categories, and they all involve orders to be submitted or trades to be concluded on the market. And then the fourth category is the dissemination of false and misleading information, which is an off-market type of market manipulation, which can happen without market participant going onto the market and trading or submitting orders. It goes, it can, for example, mean transmitting misleading information through the media or through any other mean, including chat or text messages and so on and so on. So those are kind of the four higher level categories, and then these are examples, more specific examples of abusive behaviors, which are not in the regulation anymore, but which are listed in this ACER guidance that I mentioned before. So these are specific behaviors. For example, wash trade layering, we have the guidance notes about them, capacity withholding, marking the close, and so on and so forth. They are all mentioned in the ACER guidance or in the ACER guidance notes. And I will focus on these three just to give you a flavor, kind of a more concrete example how market manipulation can be done. So first example is a wash trade. So wash trade is a trade where there is no change in the beneficial interest. And here we have two market participants, A and B. And what happens, A is selling to B 1,000 megawatt and B is selling back to A the same amount for the same price with a little time difference. So basically, again, no change in the beneficial interest. So why that is wrong? I mean, it is not necessarily market manipulation, but if these transactions give the impression to the market that liquidity, for example, is at is higher than otherwise it would have been, and for example, other market participants observing it adjust their behavior by introducing new orders closer to the price level of this so-called wash trade, and they are canceling and changing their orders. And we can show that these market participants were misled by these signals because, for example, they were led to believe that a new generation capacity was back online without a proper disclosure, hence this huge amount that was traded on the market. Then potentially we can conclude that this behavior was manipulative. Just please bear in mind that we are now on a wholesale energy market, on an exchange, for example, where the participants, they only see the shared order book, and I will explain a little bit more about this in the next example, but they don't know who is behind the order and the trade. So they don't see market participant A, they don't see market participant B, they just see that there is a big buy interest, and then there is a big sell interest, and then a concluding trade at a certain price level. And this can give false and misleading signals as explained. So one particular behavior is wash trade. Another is layering, and it's a bit more complicated, but I will give it a try.
I'm afraid that we have to come to the conclusion.
Okay, I have to rush forward.
Yeah, okay.
Okay, so layering, maybe just one thought. This is done through orders that are non-genuine, that would mislead the market. So even through orders, not only through trades, like in the wash trade, you can mislead others. Going on, capacity withholding. If you're not offering your capacity, your generation capacity in this case, even though it's economic for you, and you don't have any technical reason also not to do so, then you may impact the price. In this example, you can push up the price, and this can also amount to market manipulation under REMIT. So just another example. And I will conclude now, Mariusz. This is my last slide, which is the decisions from the regulators, the REMIT decisions, and the fines levied. Just for information, this is all collected on the ACER website. And going forward, I believe Piotr will go more into the details and will show you some concrete examples from these decisions. So that would be it then. Thank you very much. And
thank you very much. That was really interesting presentation, Daniel. I hope we'll be able to develop all these issues, not only during the afternoon session, but also during the next seminars with you. There's a lot of questions to you from the audience. So let me present the first one. Could you explain the value of having a tailored framework for electricity and gas as opposed to wide framework, for example, MAR, which applies to a wider set of commodity transactions? I believe that this question relates to the relations between REMIT and other more general framework like MAR.
Danny, are you unmuted?
Sorry for that. So very good question. This is a question that was debated heavily 10 years ago when REMIT came about. Whether we need a sector-specific framework fighting market abuse, or we need just an overall arching regulation. And then the conclusion was that we need a sector-specific framework for energy, for electricity and gas, because they were deemed different from financial instruments, for which we have another framework, which is the market abuse regulation in Europe. So the legislator felt that that energy markets are specific and they deserve a separate regulation. They are different because of the nature, you know, electricity and the grid has to be balanced, and then trading goes from forward towards real time. Many specificities that has to do with the specific physical reality of electricity mainly, but also gas. So this is why.
Thank you very much. The second question is I think more general in nature. It goes as follows: in regard with price positioning, what is the basis for bidding on spot markets for generation companies? How shall regulator control if the price is manipulation or not?
Yeah. I mean, this is the so the big question. I mean, REMIT, like we can have examples and we can have concepts, but at the end of the day, REMIT will work on a case-by-case basis. So each case will be different, and the regulator will have to look into the idiosyncratic, situation of each case. But in general, I mean, one thing that the regulators need to look into is intention, because if there was an intention to manipulate the market and there is a smoking gun in the hand of the regulator, for example, in the form of an email, then the case is rather easy. Then the other thing that the regulators need to look into is the impact on the market, how the behavior of the market part of the manipulator in this case, or the alleged manipulator, influenced others. Did other market participants change their behavior? Did other market participants believe that the price is a result of the supply and demand, whereas it was set artificially by the manipulator? So intention and market impact are the two angles to go about.
Thank you very much. Before I give the floor to our friends from the United States, let me ask you the last question, which comes from the audience. Why is ACER not involved in the enforcement of market breaches, but only NRAs are? I believe this is the question about institutional balance between ACER and NRAs in the EU.
Exactly. I don't know if this question is coming from a European participant from another continent. I mean, it has to do with the balance of powers and the sharing of tasks between member states and the EU. And typically enforcement is done on the member state level, also in other sectors. And I mean, it has many reasons, and but perhaps I mean, one is that member states are just closer to their market participants and to their markets to efficiently enforce REMIT in this case.
Thank you very much. Thank you very much for your interesting presentation and all your answers. And now we are sailing through the ocean to our friends from the United States. We have with us Jay Madson, who is branch chief at the Office of Enforcement Division of Investigations at FERC. We have also Nancy Bowler. She's a branch chief at the same office, but in the division of analytics and surveillance at FERC. And last but not least, we have Mike Deliso, who is branch chief at the Office of Enforcement Division of Analytics and Surveillance at the Federal Energy Regulatory Commission. They are going to give us a presentation on market surveillance and regulatory powers, including historical view, context, and legal and authority and surveillance structure. So I'm not sure who starts. Jay, is it you?
Yeah. Yes, it is. Thanks, Mariusz. And to everyone for allowing us to share our experience with you this morning. I feel a little bit like the opening act at a rock concert. I'm going to talk to you a little bit about a very brief history of the development of the market in the United States, in the legal underpinnings of our manipulation authority. And then I'm going to hand off to my colleagues, Nancy and Mike, and they're really the main act, the ones that you're waiting for. So with that, let me go ahead and do my opening set and say what I need to say so that they can give you the really important information. We are generally required whenever we speak outside of our agency just to reflect on the fact that we are speaking for ourselves today. It is not for the commission or for the chairman or for any of the commissioners. So to the extent we make a mistake, I hope we don't, to the extent we make a mistake, that was all about us and probably about me. Mike and Nancy will be great. Here is a brief overview of where we fit into our agency. We're broken into various offices. Our office deals with enforcement, and then we break down into divisions and from divisions into branches. And you can see I've circled Nancy and Mike are over in the Division of Analytics and Surveillance. They do the really technical and analytical side of things. I'm in the Division of Investigations. We are generally all lawyers and conduct investigations, and in the cases where they're necessary, we'll litigate them in court. So let's talk a little bit about the history that got us to where we are today. In particular, we started in the late 1800s is when the electric grid in the United States was first being built out. New York City and San Francisco over in California were the areas where it first started building out. As the urban areas built, as you may know, in the United States, we have a system of federalism where the states are really the originators of legal authority, and then the federal government has to step in when there are issues in particular that are related to interstate transactions. And in particular, as the grid built out and there started to be more and more transactions that went from one state to another, it became clear that the federal government needed to regulate the arena. They did so in 1935, in particular with the passage of a provision of the Federal Power Act that gave the predecessor to our agency, what was then the Federal Power Commission, jurisdiction over wholesale sales in interstate transmission. Now, interstate transmission turns out to be all transmission in the United States, not just part of it. Wholesale sales, of course, are not retail sales. Jurisdiction over that is still on an individual state-by-state basis. For several more decades following that, the energy industry and the electric industry in particular was expanding. The country was becoming more and more electrified. And then in the 1970s and 1980s, in particular in the 1980s under the presidency of Ronald Reagan, and at the same time that Margaret Thatcher had similar philosophies in the UK, there was widespread deregulation throughout many industries in the United States. You see some of the examples here, such as phones and planes and trains. After those various industries had gone through their deregulatory movements, it eventually went to natural gas. And then last but not least was electricity, maybe because electricity has proven to be the hardest of the industries to deregulate. The key order in the deregulation movement and the movement towards competitive markets in the United States was order number 888, which was issued in 1996. And what that did in a nutshell was laid the groundwork for a level delivery playing field. It was at that point that the common thought on whether or not an electric utility was a natural monopoly was rethought so that the delivery mechanism was considered a natural monopoly, but not the generation mechanism. So at that point, if we opened up the delivery system, opened up the transmission system so that everyone could use it on similar terms, the same prices as well as the same terms and conditions of service, including the utility itself, we now had a level playing field at which the generation sector could actually compete. And at the same time, there was an encouragement by the federal regulators to develop what we call ISOs, independent system operators, and then a cousin to that, which has really taken hold in the last 20 years and is the modern structure of regional transmission organizations, or RTOs. And what that was really a combination of utility assets so that you had a much broader delivery system that was within a single footprint. So you can see, for example, if you look in the map that's up on the slide now, you have these very broad geographical areas that may encompass the assets of 5, 6, even 10 different utilities that have come together so that the delivery system is broad and you can provide delivery to all of the participants at a single price. In that way, you could get the critical mass of generation that one would need in order to have true competition, true supply-demand dynamics. We did hit some bumps along the road. I told you a moment ago that 1996 is when Order 888 was issued, and that was the foundation for our competitive markets. But we had a problem in California, which I think made headlines and many of you may know about, where the market malfunctioned. We had prices that spiked. We had lots of blackouts. We had one of the major utilities out there, PG&E, Pacific Gas and Electric, file for bankruptcy. At the same time, Enron, which had been one of the major proponents of competitive markets, it turned out had been engaged in a behavior both in the markets and in their own corporate structure that was problematic. We also had, and this wasn't as big on headlines, but it was also a dynamic that was there. You suddenly had a lot of developers of generation that wanted to get connected to the grid so that they could compete, and interconnection requests went up very high, and the utilities that own the grids didn't have the manpower in order to process those interconnections very quickly. So you had a backlog of generation trying to get into the marketplace. All of those problems led, and I'm going to shift now from the historical context to a little bit of the legal basis before I hand off to Nancy and Mike, that led with those market bumps into the adoption of the Energy Policy Act of 2005. That was an incredibly comprehensive piece of legislation in the United States. It touched on almost every aspect of the energy sector. I'm going to focus for a moment on the electricity sector, and in particular, if you look at the last bullet down at the bottom, is the increased ability to penalize. Our agency is currently called the Federal Energy Regulatory Commission, FERC, and we had very small penalties for most of our existence and the existence of our predecessor agency. And it was with the passage of the Energy Policy Act of 2005 that we were authorized to penalize up to $1 million per violation per day. Never done that, but we have that authority, and that is sufficient to allow us to have more meaningful penalties when we find conduct that is inappropriate. And what conduct is most inappropriate is market manipulation. We have statutes, federal statutes that address market manipulation, both in the Federal Power Act as well as the Natural Gas Act, and that has been digested into regulation that we have, which we call 1C. So if you ever in the United States hear somebody say there was a 1C violation, what they're talking about is they're talking about market manipulation. I won't delve too far into the language, but a couple of points in the highlighted, the bolded language here from the statute. One is up the top, any entity. Our manipulation authority goes not only to corporate entities, but entity has been defined to include people, human beings as well. And we do pursue cases against individuals in addition to corporate entities. And then also note that it needs to be in connection with our jurisdiction, which gives us a little bit of flexibility if there is some sort of behavior that's happening just outside our jurisdiction, but it's affecting the markets that we regulate. That area is still a little gray at the moment, even though we're 15 years into this statute. That has been tested a little bit. And in fact, about 10 years ago, we had a small dispute with another agency, the CFTC, which tends to regulate swaps and more financial trades than we do. And ultimately, the court decided that in that particular instance, the CFTC had jurisdiction. So if you were doing a Venn diagram, you'd see an intersection that's still a little mushy as to what the CFTC regulates and what we regulate. That statutory language then got boiled down into the regulatory language, as I mentioned. It's very similar. What you don't see there, but what is key, and you heard earlier speakers talk about this, is intent, or what we call in the US scienter. You need to either have intent or be reckless in the way you went about behaving in the marketplace. And I will say, with perhaps one or two exceptions, all of our cases have really always rested on intent. One last thought on our manipulation authority is that the scope of manipulation is not intended to be all-encompassing. The commission itself issued an order noting that this wasn't a broad net that was necessarily going to capture every common law fraud that had occurred, but that it was very specific. We initially were relying on precedent by the Securities and Exchange Commission, which is an agency that deals specifically with securities. They had a robust history already in the area of fraud. So initially we relied on them, but more and more we're developing our own precedent and relying on that as we go forward. There's my scienter slide with intent. And one last thought is the market tells us, asks frequently, can you tell us exactly what manipulation is? What are the examples of manipulation that we need to avoid? And the problem with that is that manipulation is very creative, and it's hard to anticipate what manipulative conduct is going to be. To some extent, as the regulators, we are constantly chasing manipulation. We don't know something new is manipulative until it actually happens. So our answer has consistently been no, we cannot give you a list. You have the principles of what manipulation is, and when we see something new, if we think it's manipulative, we're going to pursue that. So in order to pursue manipulation, one of the keys is that we need a robust surveillance system. And while I am in investigations, Mike and Nancy in analytics and surveillance have been working for many years now on implementing that robust surveillance system. And let me turn over to them to discuss that in more depth.
Thank you, Jay. As Jay mentioned, and as our speakers from ACER also alluded to, there's no exhaustive list of manipulative behavior that we look for when we survey the market. However, there are some common themes in the type of trading that we flag in our market surveillance here at FERC. And Jay, you're going to have to drive this next slide.
Nancy, the button is not working. I wonder.
Okay. Let me, okay, there we go. Before I think I just mentioned there are some common themes, but before I discuss those themes, or what we call our tool target benefiting position paradigm, I'd like to step back and give a quick overview of the landscape of the power and gas markets here in the US. I will briefly discuss the challenge of surveilling the markets, go through the framework itself. We will also get into some data because, again, as our friends from ACER mentioned, that's pretty key to having a robust surveillance program. And finally, Mike will finish up with a broader look at the surveillance process. Next. Jay already showed you or talked a little bit about the regional transmission organizations, and they cover about 2/3 of the United States. What's interesting and maybe a little different about our markets here in the US is that we have these markets which are auction-based and operate spot markets, and these are also the organizations that are responsible for reliability. Overlaying these are the traditional bilateral and futures markets, both in power and gas. And while the CFTC has exclusive jurisdiction over the futures market, there is some overlap, and we have a close collaboration with them that Mike will talk more about. On the right side of the map, I'll go back one, is a more granular look at the RTO markets. And you can see that these are pretty granular. There are over 35,000 pricing nodes that are produced every 5 minutes, both in the day ahead and real time. That's just a snapshot of 1 5-minute snapshot. And there's a pretty wide variety of prices that are produced. Next. Because of the complexity of the market, an exhaustive classification of manipulation schemes is pretty impossible. However, we can broadly divide these into cross-market manipulations, both cross regions, the RTO regions, cross products, and also, you know, reaching across to the natural gas markets between the power and natural gas. The other major category is gaming of market rules, and that is something that we see a lot of. Getting to our overarching framework that we use to think about most manipulative schemes in our markets, we first look at what kind of tool that a market participant might be using to do a market manipulation. And in our case, because we have jurisdiction over physical, we're often looking for a tradable instrument that is physical in nature. And we also look for uneconomic or suboptimal trading. Also, the tool, you know, getting to the idea of scienter that Jay talked about, does the tool have the goal of affecting an index price or sending a false signal to the market or market software? And is the market manipulator trying to target an out of the market payment? The target are these indices and market software, and the kind of benefiting positions that we look for are you trying to move the market in order to benefit some larger position that you have in a swap or futures contract? Additionally, there are products in these regional transmission organizations that have swap-like features, most notably something called financial transmission rights that are somewhat similar to basis swaps. You could also be trying to move the market to benefit your generation portfolio. And finally, these RTO markets have a large number of make-whole payments that take place outside of the market construct. Accurate and complete data is necessary for market monitoring purposes, and our codes use both a mix of public and non-public data. At the top of these, and most important, we have two FERC orders that came out, Order 760 in 2012, most notably. This order allows us to get regional RTO market bids, offers, and awards. These come directly from the RTOs and are processed by us at FERC. And we also get data through Order 771, which are electronic tags, and these give us scheduled transmission paths. Mike's going to talk to us a little bit more about the data that we received through a memorandum of understanding with the CFTC that gives us access to data relevant to both gas and power markets.
Hello, everyone. I'm Mike DeLisa. I'm the branch chief of natural gas market surveillance. Can you hear me all? Yes. Okay. So as Nancy was discussing, we get data through memorandum of understanding, both with an exchange in the US called the Intercontinental Exchange, which manages an over-the-counter physical market for both natural gas and non-RTO power. The Commodity Futures Trading Commission, CFTC, another government regulator, has a report of all of the large positions in financial swaps, both in the gas and power market. And those are critical for us to analyze cross-market manipulations. On top of that, as Nancy alluded to, we use a mix of public and non-public data. We make use of third-party services to parse that public data, to include data from the states, from other regulators, from the markets, and even from ourselves to include data sources like the EQR, Electric Quarterly Report. Next slide. So in surveillance, we're really in the heart of DAS's work. DAS engages in data engineering work. Surveillance certainly does that on its back end coming in. Surveillance engages in all of the tool development and the reporting on what's going on in the markets. And we work to develop cases through an inquiry process to make eventual referrals for formal investigations within the commission, which we support and also our investigative branches support. Next slide. As I alluded to, we have vast data infrastructure that makes this all possible. We have a dedicated branch inside of DAS that deals with data matters and provides an interface with us to the rest of the buildings and the rest of the commission's IT. They ultimately provide environments, they manage the incoming data, and they manage the commercial products that we make use of. On the surveillance side of that, we have to figure out how to get all of that data together. We do a lot of metadata development, we develop the data models, and we create the backend views and data marts that ultimately support our surveillance. We build reports upon this, we build interactive tools upon it that enable our continuous work. Next slide. So as Nancy alluded to, and also our European counterparts alluded to, there's a set of schemes that we have to examine all the time. And there's a whole host of screening criteria that we use in both the gas and power markets. Core to a lot of these, I've put some select metrics here, but we make use of leverage metrics, essentially analyzing the size of exposures to positions, both financially or in terms of some kind of physical index exposure or asset exposure, relative to the underlying amount of physical activity. We look at how much a market participant has an ability to influence the price, how much of the market they are they basically marking the beginning of it through framing? Are they marking the close? And last, we look at behavior. We're often looking for economic indifference. We're looking for someone actively engaged in buying on the upticks, selling on the downticks, or manipulating auctions in a similar fashion. Next slide. So the work that we do in surveillance is extremely extensive. Beyond the data development and the tool development itself, we engage in regular reporting processes. So we're constantly analyzing what are coming off of the markets, both from our tools and what's coming from the trade press. We engage in review and follow-up. We, both in gas and power surveillance, we engage in weekly reporting on a monthly cycle, analyzing all of the core physical markets that we have views into. We have tracking processes that are in internal dashboards. We build metadata on top of our reporting processes, and these inform monthly and annual reporting as well. And the whole point of this is to, ultimately develop cases. We have an inquiry process. Those inquiries range from informal to formal. And ultimately, those inquiries base themselves off of what comes in through an enforcement hotline that the Division of Investigation maintains, what comes in referrals from what are known as the market monitor units associated with all the RTO ISOs, and then also from everything we do in surveillance ourselves. The inquiry process, oftentimes we're engaged in company outreach to get the best picture of what occurred. Most of the time, this direct communication is extremely efficient, provides an explanation, and closes the case. On occasion, it develops into a referral in which we make a formal referral over to the Division of Investigations and proceed with our investigative process. So with that, I know that we'll get straight over to Q&A. So thank you very much.
Thank you. Thank you. The United States legal framework related to market manipulations is an older brother of European REMIT. There's a huge interest in your presentation, and there is a lot of questions. The point is that I can ask only one question during this live Q&A session. So let me pick this one which relates to the future, and it goes as follows. As energy markets are evolving, do you think that market surveillance practices will be evolved in the future? I mean, nowadays systems specifically focuses on entities, but will it be possible to consider and consumers? And consumers in line with market surveillance? Will they be responsible for not consuming less in time of crisis, given given the fact more inclusion of end consumers in power markets, for example, both in terms of production and consumption side. So I believe this question relates also to another one related to demand side response. So what is your opinion about the future of market surveillance?
Well, I'll take a first crack, but let Mike and Nancy, when I go off the rails, give a better answer. And if there's been anything that's been true over the last 20 to 25 years in the electric and gas markets, it's that they're constantly evolving. But for lots of reasons. One, because the market has gotten creative with trying to come up with different ways to approach the problems that we have. Part of it is as we continue on a technological basis to come up with new forms or more cost-effective forms of generation. For example, the first offshore wind farm, which I know the US is lagging behind other parts of the world in that respect, but we've got our first offshore wind farm that's finally got approval to go forward. And in addition, on the demand side, as we hopefully get more and more efficient, for example, automakers that seem to be all now moving towards having fleets that are hybrid or hopefully all electric. So there'll constantly be changes as we go forward. A little bit on demand side, and then I'll Mike and Nancy, you should jump in. Is demand side from an enforcement perspective has been something that's been on our radar screen now for at least about 10 years. Demand side management is playing a greater and greater role, right, in capturing that top part of peak demand. And in fact, we had a rather fun case, if I can describe an enforcement case as fun, back about 10 years ago when the baseball stadium in Baltimore was going to be paid for providing demand response. And what they did when it was time to measure how much demand they used in the middle of the afternoon, they turned all of their lights on and they had everything that they could turn on, they turned on so that they could inflate their load so that when the time came, they would have to do nothing and would just get a stream of dollars. So demand side has absolutely been a piece of what we've been looking at for some time. Mike, Nancy?
I'll let Nancy take
Sure, I can jump in.
Sorry, I guess what I was just going to say briefly is just, you know, we're dependent on a lot of third-party data scraping services, and we always make value of new information that emerges from the markets. A lot of the function that we provide is, you know, situational awareness of what's going on in the markets, and that constant debate we're engaged in is whether, you know, items are market manipulation or whether they're market design flaws. And if more the latter, the kind of things that we can do to fix things and inform better policy to better make our enforcement effective. So getting to the demand side matters. I'll switch over to Nancy for the electric side.
Sure. I was just going to say that one of the things that we try to do in surveillance is always keep ahead of the new market rules that are coming out. And it's also quite challenging, especially in the electricity markets, which are moving much more quickly than the natural gas markets, that there are the data that we receive from the RTOs is constantly changing. So as soon as you create one tool for looking for one type of market manipulation, a new rule comes out, the data changes, the way people trade changes. So we try to be as creative as possible in keeping abreast of things. Some of the most notable things that are happening right now, I think Jay alluded to demand response. There are more demand response resources coming up onto the system right now. And because the way the markets settle is inherently settled on the supply side of the market, there are some unique ways that the demand response can game the market, even over and above inflating the baseline, which Jay alluded to. But in addition, we have new orders on incorporating storage into the electricity markets. It's mostly batteries right now. And we've seen that's under Order 841, and we've seen that grow pretty exponentially. We also have this new order 2222, which will incorporate distributed energy resources into the market. And that's coming down the pike. So as a surveillance group, we try to stay ahead of that, anticipate it. Our data group within the Division of Analytics and Surveillance also speaks on a regular basis with the RTOs and with their data folks to get ahead of what kind of new data we're going to be coming in and how we're going to ingest it. So I think that is all I have.
Nancy, Jay, Mike, thank you very much for this great introduction to the U.S. legal framework related to market surveillance, and for your answer. What I'd like to ask you is maybe to address all the remaining question directly via this chat box to just to satisfy all our audience which is really interested in the current and future developments of the US anti-fraud system. So thank you very much once more. Let's have a technical break. We have only 5 minutes left to the next session. So let's have a short break and see you after see you in 5 minutes. Thank you. Well, welcome again. Before we start the next session, I got an announcement. This is the first seminar in the ERRA series related to market surveillance. During next editions, we will present institutional issues in the first part and case studies during the second. So this second session of today's seminar is devoted to case law, to case studies, and I have a great pleasure to announce the first speaker, who is my colleague, Piotr Suski. Will present us types of market manipulations in energy markets in light of European national regulatory authorities case law. Piotr, the floor is yours.
Thank you, Mariusz, and thanks ERRA for organizing this really interesting webinar. In my presentation, I'd like to provide you with general overview of sanction decisions issued so far by national regulatory authorities from EU states under REMIT, And in this context, I try to point out what types of behavior were qualified as market manipulations in energy markets by those regulators. We don't have time for thorough analysis of the case law, but I will mention essential elements that comprise the manipulative conduct in several cases. Let's begin with some introduction to REMIT sanction decisions. As you can see, REMIT regulation does not harmonize sanctioning powers and sanctions applicable to REMIT infringements, including market manipulations. They are laid down by member states in national law, and therefore in different jurisdictions we have different models of sanctions for market manipulations in energy markets. First of all, in some member states there are only administrative sanctions, such as administrative fines. This is actually the case of most EU states. In this model, sanctions are generally imposed by a national regulatory authority, such as state agency or board which regulates energy markets, and they may concern legal persons or natural persons. On the other hand, there are member states, such as, for example, Denmark or Poland, which implemented only criminal sanctions model for market manipulations in energy markets. In this case, NRA may have investigative powers, but imposing sanctions belongs to public prosecutor or court. Usually, criminal sanctions may concern natural persons. However, in case of criminal fines, national law may provide that legal persons are also subject to such sanctions, as it is, for example, in Denmark. Finally, some member states, such as Germany, introduced dual system of sanctions for market manipulations in energy markets. Both administrative and criminal sanctions imposed either by NRA or by public prosecutor or court. Now, as you can see, the picture is quite complicated, but so far most sanction decisions have been issued by NRAs and imposed only administrative fines on legal persons. Only in 2 cases, fines were imposed or actually agreed with public prosecutor, and in 1 case they concerned not only company but also traders involved in manipulative behavior. Now let's look at some statistics to give you a broader perspective. As you can see, 15 sanction decisions have been issued under REMIT so far, and 10 of these decisions are final. All of them have concerned prohibition of market manipulation. So one of the 2 market prohibitions provided for in REMIT. That means that under REMIT there is still no sanction decision concerning insider trading. The total value of imposed fines is approximately 83.5 million euros. So the average value of fine is equal to approximately 5.5 million euros. However, the actual range of fines is quite wide, from approximately 28,000 euros to 42 million euros. As you can also see, some of the NRAs are quite active in detection and sanctioning market manipulations in energy markets, while in some countries we still don't have any sanction decisions under REMIT so far. Number of sanction decisions has significantly increased over last 4 years. As you can see, 2/3 of the decisions were issued in 2018 and 2019. On the basis of such background, we can try to systematize types of market manipulations and divide them into 3 groups. This isn't any official classification, but only my proposal on how different types of market manipulations can be divided. So taking into consideration NRA's sanctions decision, we can distinguish between market manipulations which are specific for energy markets. Secondly, transaction or order-based market manipulations which are specific not only for energy markets. And finally, market manipulations comprising dissemination of false or misleading information. The first group, as you can see, includes so-called transmission capacity hoarding and capacity withholding. These types of manipulative behavior can be considered specific for energy markets, as market participant is using or offering capacity of energy infrastructure in a way which gives or is likely to give false or misleading signals, or which secures or attempts to secure the price at an artificial level. So we have some direct link with offering or using capacity of energy infrastructure. On the other hand, we can distinguish a large group of transaction-based or order-based manipulations, which are, as I've mentioned, not specific not only for energy markets, as similar manipulative conducts are common also for financial markets or other commodity markets. To this group, we can include, as you can see, among others, layering and spoofing and marking the close, which are covered by present case law. And finally, third group, which consists of spreading false or misleading information through the media and other behaviors designed to spread false misleading information, as REMIT provisions distinguish also such type of market manipulations. As you can see, if we apply this division to sanctions decisions issued so far, only 1/3 of them concern market manipulation specific for energy markets. So we can say that the nature of market manipulations on different markets are very often similar. Let's move to the examples of manipulative behaviors. First, I would like to discuss transmission capacity hoarding. Under REMIT, this type of market manipulation has been identified on intraday electricity markets functioning with a single intraday coupling mechanism. This mechanism allows market participants to trade electricity across different bidding zones in EU, using implicit allocation of transmission capacity. That, of course, means that both transmission capacity and the corresponding quantity of energy are allocated at the same time. And what is also important, the allocation in set cases was made on a first-come, first-served basis, which resulted in that capacity was acquired at a price equal to 0. Including situations when its value was greater than 0. So the market participants acquired, in particular time frames, all or decisive part of the available transmission capacity between certain bidding zones through buying and selling simultaneously contract for the supply of electricity in certain bidding zones. I should also mention that according to ACER guidance note on capacity hoarding, as decisive part of capacity, we should understand an amount that is potentially capable to reduce or hinder price convergence between connected bidding zones that would otherwise happen due to the interplay of supply and demand. In the cases we are interested in, the market participants acquired all or decisive part of the available transmission capacity, but in such a way that they actually didn't deliver any electricity between bidding zones. This was due to the fact that they performed reverse wash trades in those bidding zones, through selling energy in bidding zone A and buying it in bidding zone B, and at the same time buying energy in bidding zone B and selling it in bidding zone A. So in fact, that was case of non-used transmission capacity as none of the electricity was delivered. As you can see, according to ACER guidance, no transmission capacity hoarding can occur also if market participant is using capacity non-effectively, which means that capacity is acquired with the purpose of preventing other market participants from using it, or to create or enhance a price divergence between bidding zones. Of course, this needs to be proven by NRA somehow. What I also want to point out is that the notion of transmission capacity hoarding can be understood wider, for example, as long-term reservation of transmission capacity by operator to another part of his vertically integrated undertaking, depriving other market participants of access to this capacity, and such practices were qualified in the past by the European Commission as abuse of dominant position and sanctioned under EU antitrust law. Let's move to capacity withholding. This type of manipulation may take two forms, which are physical withholding and economic withholding. In the first case, capacity withholding consists of not offering or limiting without justification available production, storage, or transportation capacity on the market by the market participant with the relative ability to influence the price or the interplay of supply and demand. So as you can see, physical withholding may concern different types of capacity. So far, NRA's identified cases which can be qualified as withholding of production capacity by electricity generator, but also withholding of transmission capacity by transmission system operator. In this latter case, TSO unjustifiably limited available transmission capacity of electricity interconnectors between two member states. This was result of incorrect application of internal procedures concerning calculation of available transmission capacity. Nevertheless, NRA qualified such behavior as market manipulation. The second form of capacity withholding is economic withholding. This is defined in ACER's guideline as offering available generation capacity at prices which are above the market price and do not reflect the marginal cost of the market participants' assets, which results in that the related energy product is not being traded or asset is not being dispatched. And ACER proposed two-element test to assess generation capacity withholding, which includes firstly assessing whether the market participant is able to influence the price or the interplay of supply and demand of certain product by engaging in withholding. For example, if certain market participant is pivotal supplier in certain market and certain time frame. And secondly, assessing whether the market participant has no legitimate justification for its behavior. So far, generation capacity withholding has been sanctioned under REMIT once by Spanish NRA. And in that case, regulator stated that one of the generating companies had deliberately increased prices for electricity from its hydroelectric plants dispatched in the day-ahead market by reducing the electricity offer volume, despite the fact that the prices were notably higher than in previous weeks. The analysis of NRA showed that such behavior was not justified by an exhaustion of its hydroelectric capacity because the volumes held in its reservoirs were higher than those in previous years. And at the same time, it was not justified by expectations of future prices as forward contracts were indicating prices lower than those applicable in the day-ahead market. And in this case, I also should mention that the generation capacity withholding was qualified in the past by European Commission as abuse of dominant position and also sanctioned under EU antitrust law. Let's move on to these market manipulations, which are specific not only for energy markets, as you can see, EU NRAs have identified several cases of layering and spoofing in energy markets, which are quite similar to each other, so we can discuss them jointly. Both types of behavior comprise two common elements. First, it is the issuing of non-genuine orders on one side of the order book. In case of layering, market participant usually issues multiple non-genuine orders at different price levels on one side of the order book, and in that way he creates price layers on the buy side or sell side of the book. In turn, in case of spoofing, market participant issues usually single large or multiple non-genuine orders at the same price level on the buy side or sell side of the book. Such actions are taken to influence the other market participants' behavior, for example, by creating the impression that there is stronger selling or buying interest at decreasing or increasing price levels than there actually is. So market participant, which is issuing non-genuine orders on the one side of the book, aims at entering into transactions at better conditions regarding price or volume on the other side of the order book. In result, said market participant is able to enter transaction or transactions on the other side of the order book at a price that is better than he could have achieved in the absence of manipulative behavior. And these transactions usually occur within a period that allows the non-genuine orders to influence the behavior of other market participants. And finally, those orders are usually cancelled shortly after the entering into one or multiple transactions on the other side of the order book. Such practices can be quite complex and extended in time. For example, in one of the sanction decisions, French NRA identified 65 cases of layering spread over 54 days. And during these events, market participants generally led several sell orders at the beginning of the trading day. And as the day moved along, he gradually decreased the prices of the sell orders. And once the prices had decreased, market participant led buy orders and cancelled its sell orders. And according to NRA, this course of action was likely to give misleading signals to the market in the supply and demand. Another type of market manipulation, which is specific not only for energy market, is marking the close, which consists
Piotr, so sorry for interrupting, but we have to slowly come to the conclusion.
Okay, which so the marking the close is specific not only for energy market, and generally it consists of buying or selling wholesale energy products deliberately at the close of the market in an effort to alter the closing price of the energy product and secure it at artificial level. Just to give you an example, in one of the sanction decisions, Spanish NRA identified that market participant who was a typical net seller of gas executed on the exchange 2 minimum volume transaction of gas as a buyer of the day-ahead product. And these transactions were executed at close of the market and at prices 7%, at prices level 7% higher than the one at which the same market participant had sold natural gas just a few instances before in the same market. And this price was also significantly higher than the prices prevailing on the OTC market. So as I'm running out of time for my presentation, I just briefly mentioned that according to NRA decisions, also different forms of disseminating of false or misleading information may constitute market manipulations under REMIT. As you can see, this can be submitting different information by TSO to market participants or to TSO by market participants. And I think that I will finish with that. Thank you very much.
Thank you very much, Piotr. To all of you, we'll try to develop all these particular examples of market manipulations during during the next seminars. There is a lot of questions to you. Let me ask you one more, and then ask you to address the others directly via the chat window. So the question to you, Piotr, is whether economical capacity withholding is a debatable concept, hard to defend and prove in court, because it requires calculation of marginal cost of a particular player.
Yeah, I could agree. I can agree with that. I think that this is a quite complex type of manipulative behavior, and to prove such type of manipulative conduct, we need to engage quite complex economic analysis. So to compare the prices of certain electricity generator with other market participants, compare his prices with his marginal cost and other costs. We have to check the other justifiable other justifications, economic, technical, and so on. So this is definitely hard to identify, hard to prove. And maybe this is why we have so far only one sanction decision which concerned economic withholding.
Thank you very much for your very interesting presentation, Piotr. And the next presentation is devoted to types of manipulation under US law, and I'd like to ask to Jay Metson, Ben Jarrett, and Jordan Hinz from FERC to present and identify these types of behavior that FERC considers to be inappropriate market manipulation. Jordan, the floor is yours.
Hey, Jordan, it looks like I'm seeing the presenter view on this. I think if you go to display settings and do duplicate, I think we'll get what we need. Maybe not. Try to restart the presentation. There we go. That looks good. We lost you.
Give me 1 second, trying to navigate here.
It was up right before it exited out. I don't know if that was purposeful or not.
Are you seeing the presentation?
Yep.
All right. I'm trying to find a way to see my notes here, and I'm not sure how to do that. Okay, well, I'll try to move through this. I just want to say thank you to Mr. Swora. Thank you to ERRA for having me today. Is my video on? I'm not sure. Well, I'll just continue. So before I go any further, I just want to say that the views expressed here are my own and do not reflect the Federal Energy Regulatory Commission or the views of the chair or any individual commissioner. So today I just want to present the topic of cross-product manipulation. This term refers to uneconomic trading, transport, or asset management in a physical market to increase the value of a financial derivative position. This uneconomic trading can refer to physical gas transactions or uneconomic pipeline transportation, uneconomic storage or injection or withdrawal movements. In addition, on the power side, there can also be uneconomic power transactions as well. I'm going to focus on the gas topic, and the specific case I'll talk about today will refer to natural gas. But this is just the general paradigm that we observe typically. So speaking specifically, in the fall of 2008, Hurricane Ike was approaching the Gulf Coast of Texas. That tropical storm made landfall on September 13th, 2008. And as a result, a lot of demand fell in that Houston Ship Channel area. For those that are familiar with the Houston area, there's a lot of petrochemical and industrial users in the area. And when this storm approached, many of those users shut in their demand and ceased operations, as the storm approached. As a result, demand fell, and following that, prices fell as well. We observed a market participant noticed that its short financial positions benefited from the lower index prices at Houston Ship Channel. And we observed this market participant engage in a scheme to keep those prices depressed to their financial benefit, of course. Once the market participant observed the benefit to their financial derivative position, they began in this cross-product manipulation. So they used their physical assets, including physical sales at Houston Ship Channel, as well as pipeline flows from a nearby location to Houston Ship Channel to essentially flood the market with a surplus of gas. As a result, prices remained depressed, and the financial derivative position held by this participant benefited about $3.5 million for the month of September, the latter half of September. In the pursuit of this windfall, we observed the market participant increase their financial positions, their short financial positions for October and November, and to continue this scheme into those months. And to speak more generally here, if we're talking about a supply and demand balance, and we increase supply, typically the economic effect is to lower prices. So we observed this market participant engaging in physical flows from a nearby location to this Houston Ship Channel point with the intention of keeping those prices suppressed. And as a result, their financial position benefited from this activity. So I just want to reiterate a paradigm that Nancy presented earlier. We talked about a tool, target, and incentive. And in this instance, the tool was physical gas sales at Houston Ship Channel, the uneconomic flows from a nearby higher price location to Houston Ship Channel. And the target, of course, is the Houston Ship Channel Daily Index. When this participant is trading the physical product, that physical product affects the index, and therefore these the surplus of supply served to lower that index. And once that target index was reduced, the payoff, the incentive to the participant was a financial position that settled off this daily index. And as I mentioned, they received large profits in the month of September. The activity continued into October and into early November. And as a result of this manipulative behavior, FERC assessed a fine of approximately $20 million, and disgorgement of the profits made from this scheme. So with that, I'll hand off to Ben, I believe.
Sure. Give me one sec here.
Ben, would you like me to drive?
No, I'm good. I think. Can you guys see that?
Yes.
Cool. All right. Hi everybody. My name is Ben Jarrett. I'm a branch chief in the Division of Analytics and Surveillance within the Office of Enforcement. Whereas Mike and Nancy are surveillance branch chiefs in that division. I'm a branch chief of analysts that tend to work with the Division of Investigations that Jay works in. So we work with the attorneys on the investigations. So I'm going to cover a case study involving false information. I kind of view like three broad categories of violations that we deal with. One that Jordan just talked about, sort of like the cross product, the physical for financial. One is gaming. I think Jay briefly may have touched upon it. Kind of like taking advantage of loopholes in the rules of the electric grids, or just how settlements are calculated. And then the third one is just a general, just providing false information. So that's what I'm going to get to today. And let's see, there we go. Again, general disclaimer, I speak for myself. Okay, so this case study involves a pair of DAS surveillance and a market monitor observed generators that were receiving make-whole payments that were relatively high compared to other similarly situated generators. And I guess just for your reference, our ISOs or the individual electric grids that we have, they also have market monitors that are usually third parties that do additional surveillance type work. So there is sort of two organizations kind of scrutinizing the transactions in the marketplace. Okay, so after surveillance and the market monitors observed that, they both referred those two, the company that owned those two generators for investigation, and FERC's Office of Enforcement opened an investigation. Okay, so the two generators at issue, they're both about 55 megawatts. They were dual fuel, so they could run on either oil, a fuel oil, or natural gas. However, one at a time, they can't do it jointly. It's they either run on oil or they run on natural gas. And then, however, when they ran on gas, it would cause more frequent operational issues, like shortly after it would start up, it would have a forced shutdown. So there were more issues associated with it running on gas. So in the course of the investigation, we found that they ended up wanting to repair the components that allowed it to burn natural gas. And during that time, they would only run on oil, which was generally the more expensive fuel. So when they were initiating repairs, they communicated that to the ISO. And as part of that communication, they requested higher reference levels or higher sort of prices. And we're going to get into that in the next slide. Okay, so reference level, it's generally an ISO's estimate of the generator's production cost. So it's separate from the offers that a market participant makes in the marketplace. It's like a benchmark that the ISO keeps on their end, which it's generally a function of the heat rate, which is the sort of efficiency of the unit, times the cost of fuel. And where this becomes relevant is if the ISO wants to run the unit for some reason, such as to provide the grid with extra reliability, but the unit is more expensive than prevailing market prices, then the ISO will pay the unit sort of based on that reference level, so sort of like based on its costs to compensate it to make up for the difference between its costs and what the market is willing to pay it. and that's called a make-whole payment. So they're made whole to the reference level. Okay. All right. So over the course of the investigation, we talked to numerous company employees, people at the ISO. We asked for communication documents. We looked at the financial impacts. We tried to get sort of like a whole assessment of the situation. And what we found was that the company had completed its repairs on the gas components, but still but didn't notify the ISO. So the ISO still thought it was running on oil, and if it would be paid a make-whole payment to its reference level would be paid based on a higher oil-based reference level. So they were making sort of more money than the market wanted, that the market should have paid it, and that lasted for several years. So the company went on for several years without making that notification. And over the course of the investigation, we found that there were, either misleading, inaccurate, or incomplete communications between the company and the ISO. So it seemed like it was more than they just forgot to notify them. Like I said, we reviewed emails and communications, and that's how we arrived to that. Additionally, we verified it using emissions data. So companies are required to report emissions data to an agency. And based on that emissions data that then we obtained, we could infer what days they were running on gas and what days they were running on oil. And then we could see that when they were getting paid based on oil prices, although they were running gas. So in this instance, we found two violations. One is 3541A, which basically is a FERC rule that says companies have to comply with the ISO tariffs. And in the tariff, there was basically a part in there that says they have to timely notify the ISO to adjust reference levels based on changes of fuel types and fuel prices. Additionally, our 3541B regulation is that these sellers have to provide accurate information and not omit material information. There's a due diligence clause in there, but we determined that they did not express due diligence. So the remedy here was, they actually had settlements with both ISO and FERC, which is a little unusual. They received a $400,000 penalty from the ISO, the same from FERC, and then $450,000 in unjust profits. So it's a little odd because we don't want to penalize for the same activity twice. However, the investigative team and enforcement found that there was enough activity that sort of went above and beyond what the ISO was capturing in their penalty to justify pursuing a separate violation. And I think that covers it. I want to make sure we leave enough time for Jay, and then we'll get back to the Q&A. Just give me 1 second here.
Thanks, Ben. So you heard, we're giving you 3 variations on abusive behavior here in this session. And you heard Jordan talk about cross-product manipulation. You heard Ben talk about false information. I'm going to take a second to talk about a 3rd variation, and that is targeting settlement streams of dollars. Again, this is only me talking, not the commission or any of the regulators, any commissioners rather. What I'm going to talk about is settlements, which is after the supply and the demand have been offered and bid into the market, and the market is resolved and dispatched. We know what the prices are. We can determine how the dollars are supposed to flow. because the electric market is very complicated and can't quite operate on a strict, naked supply and demand function the way some markets can. There are different streams of dollars that get moved around by the market operators. And if we find a market participant trying to capture those streams of dollars and are focused their behavior on capturing those streams of dollars rather than functioning on a basis of fundamental criteria in terms of availability of supply and demand, outages on the transmission or generation system, weather events, that we find that to be problematic. I'm going to talk in a hypothetical sense, though, for those of you who follow a little bit what the FERC does in the United States, you may see very soon an order that seems remarkably similar to this conduct. And the conduct I'm going to look at in particular is about make-whole payments. Nancy alluded to those a little earlier this afternoon, and I know there's a question in the chat about make-whole payments. So this is a particularly good hypothetical, I suppose, to talk about for 2 or 3 minutes. In a market, let's suppose that there are various statuses in which a generator can offer its supply. And let's say 2 of those statuses are market status and self-commit status. Self-commit status would be when the generator wants to be dispatched and the price that it's going to get paid doesn't matter to it. It wants to be dispatched no matter what. That could be a unit, for example, an old coal unit that going on and off is problematic and will wear the unit out. And so they just want to get on and run. And you'll take whatever dollars, whether it's a profit or a loss, that you get. Another status would be market status, where you actually submit an offer into the market. There's a certain price point that you want to get in order to be run. And if you clear in the market as the market goes through all of the supply offers and the demand bids and matches it all up, it comes up with a clearing price. And if you clear that price, you get dispatched. If you are in market status in our hypothetical market, you can receive a make-whole payment, for example, if the market price doesn't allow the unit to cover its costs. And part of that is to make sure that we don't drive units into bankruptcy. So there's a very good reason to have make-whole payments available to cover costs when the market itself isn't providing sufficient revenue to the generator to keep it solvent. So with that baseline, what you would expect is that a generator would take a look at the fundamental criteria and would decide whether it needed to be dispatched no matter what, or whether it wanted to offer in, and it would choose market or self status. So let's take our hypothetical, and we'll take a hypothetical day, and each hour, let's pretend some of those hours it offers into the market in self status. In some hours, it offers into the market in market status. Well, the self status doesn't qualify for a make-whole payment no matter what. Remember what I said is the generator is going to accept a profit or a loss, take whatever the price is for that hour. So let's ignore as you what a bad actor might do to capture make-whole payments. Let's ignore the self hours and just focus on the hours in which the hypothetical unit bids in as market status. And let's pretend that we have a certain amount of euros that the unit is able to capture during those particular market hours. And you can see on an hourly basis, sometimes it profits and sometimes it loses. The make-whole payment paradigm is structured to make sure that the unit doesn't lose money on, I'm going to grossly oversimplify here, on a daily basis. It is not an hourly backstop. It is more of a daily backstop. So in my hypothetical, we've removed the self hours because those don't qualify for make-whole. We're looking just at the market. We've got our individual profit and loss each hour. In the aggregate for this hypothetical day, the unit has lost 300 euros. As a result, it qualifies for a make-whole payment because we want to make sure that the unit is kept whole, that it's kept solvent, and we net out the loss with a $300 make-whole payment so that it's kept even. Now let's take a slightly different hypothetical day in which you can see 3 hours, I've changed the individual hourly profit and loss of the unit. And as a result of that, instead of a €300 loss, it's a €450 profit for the day. In that case, because it profited, there is no make whole payment. Doesn't matter how big the profit is or how little the profit is. It could be €1, it could be €1,000. In my example, it's €450. It does not qualify for a make whole payment. So the net is the €450 profit. It doesn't get a make whole payment. It has €450. Now let's take one more variation where we start to see the behavior that is troubling. Let's say that we have the hours on the left, hours 9 through 15, in that those profitable hours, because the unit anticipates that they're going to be profitable hours, instead of offering in market status, it offers in self status. And as a result of that, it makes €1,600 during those hours. And by moving those profitable hours into self status, it leaves on the right, hours 16 through 20, hours when the unit is incurring a loss in market status. And let me touch once again the fundamental. Only the hours where you offer in market status are relevant to whether you get a make whole payment. So those hours that are left in market take a loss of €1,150. Those hours now qualify for a make whole payment, and let's net it out. They have €1,150 loss. They get a make whole payment to that amount, which nets those hours out. But meanwhile, hours 9 through 15, which would have been bid in or offered in rather in market status in my last slide, now that those are in self, they get 1,600. And you can see for all of these hours that on the previous slide yielded, I got too clicky with my computer, yielded a €450 profit. Once you move some of them into self, you're getting a €1,600 profit, roughly €1,150 more. Did I do that right? I think I did my math right. I'm a lawyer. I don't do math very well.
Hey Jay, I think Christina's driving the presentation. I don't think you're sharing yours, so I think she's doing her best ability to keep up with you here. So I don't know if we're seeing exactly what you think we're seeing.
No, I drove it, but I clicked. I clicked too much to try and go back and show the previous.
Okay.
So yeah, so the unit, because it has moved certain market status hours to self when it's profitable, was able to isolate those losing hours, cover that with a make whole payment, and inflate its profits. And so that's another scenario that we watch for in our markets. And Mariusz, that is it for our three scenarios.
Thank you very much, Jay. Many thanks to you and your colleagues for presenting all these practical examples of types of manipulation cases under US law and your hypothetical settlement game. Unfortunately, we are running out of time, so we don't have time for a live Q&A. I would like to kindly ask you to answer all the questions from the audience that directly via our chat window, and I'd like to also ask you to take a part in the last item of today's seminar, namely panel discussion. I have two questions. One is more detailed, and it comes from the audience. I'd like to direct this question both to FERC and ACER teams, This is very interesting question, and it relates to the burden of proof. And it goes like that. Who bears the burden of proof? The regulator or the market participant that the market is being manipulated, or that it is a legitimate market activity?
Sorry, if I could just quickly ask all of the speakers to turn on your webcams, please. Thank you very much.
Okay. Thank you, Kasper.
Does ACER, Pedro, do you want to go first for ACER? Or I'm happy to go first too.
Please go ahead.
All right, so I'll go from
volunteers.
US,
okay.
From an investigatory perspective at the FERC, there's really two pieces to that. On the first piece, it's actually a little mushy. When we're investigating at the FERC, I don't know that we really think about it in terms of a burden of proof. What we do is we get an allegation that comes to our attention, we gather evidence, test it against the legal standards, and try to determine whether or not we think bad conduct occurred, a violation occurred. So I suppose in that sense, the burden of proof is on us as the investigators to cross a certain threshold of thinking that what happened was inappropriate and a violation. In a few cases, and there haven't been many that have made it this far, but in a few cases on the electric side, not the gas side, we can wind up in our federal district courts, which are the trial courts in front of a jury. In that instance, we are the plaintiff because we're asking the court to find what we found, that a violation occurred and then a penalty should be assessed. So in that case, as is traditional of civil actions in our court system, the FERC would bear the burden of proof in that instance.
So on ACER's side, I mean, ACER is not an investigatory or enforcement authority. So what I will say is kind of a secondary observation of NRAs, and this is my personal observation and not of ACER's view. But having said that, I believe the situation is very similar here in Europe, where the national regulators would gather information and try to argue their case and then share it with the company, where there is depending on national law, there is a procedure the company can reply and defend itself. But ultimately, if the regulator believes there was a breach, then can levy a fine. From where, of course, the company can turn to the court and appeal, and then it can go first instance, second instance, and so on. So that would be more or less the process in Europe.
I can add that the burden of proof is the question connected with the model of liability for market manipulations. And to some extent, this is procedural question. So as I've mentioned, we have different models of sanctions, which can be issued in different ways. In details, the situation can differ among different EU jurisdictions. For example, in Poland, market manipulations are criminal offenses, and they are imposed by the court. The penalties or the sanctions are imposed by the court in criminal procedure. So this is somehow different than administrative sanction and, for example, civil procedural. Yeah, so I think that this is quite complicated in the European Union.
So thank you very much. So the situation may be different in various jurisdictions as in relation to the burden of proof. My second question will be more general. What you think should be the role of energy regulators in the enforcement of market manipulations? I mean, what's the main advantage of regulators performing tasks related to the enforcement of market manipulations on the energy markets versus other institutions like competition authorities or financial supervisors. Who volunteers to answer first?
From the FERC side of the equation, I mean, I'll just say that, you know, one of the great powers that we have inside of DAS, the Division of Analytics and Surveillance, is that we are one of the single entities out there that has access to both, you know, what's going on in the RTO ISOs, what's going on in the physical over-the-counter markets, and what position these entities have in the financial markets. And so challenges that many of the other entities in our space have is that they don't have that full set of data access. And we are uniquely positioned in that sense to be able to detect and act on these activities. So that certainly is a reason that we're incredibly well positioned. You know, further, I'll say, obviously, you know, the enforcement actions, you know, have their beneficial effects. And one of the biggest beneficial effects is deterrence in terms of, you know, making sure that we maintain just and reasonable rates. And I believe that happens both through our investigative process and also through our inquiry process.
I also will just chime in here for a second. I think we're also well positioned to deal with the complexities of these markets as well, both just the subject matter and fundamentals, but also the complexities of how, especially the electric markets, solve for supply to meet demand. It's just very complicated, and I don't think other authorities would necessarily have the ability to sort of wade through all of those details and complexities.
And if I could just add one more thing is that we also are coordinating very closely with the regional market monitors. So we don't see it as an either or process either, that we do have very close relationships with the regional market monitors. And so there's a lot of back and forth dialogue. We discuss different market scenarios and instances of unusual trading patterns that we see, and we with them, and we talk on a very regular basis.
So there is a space for specialization, but there should also be the space for a coordination of actions between regulators and for example competition authorities. How about European perspective?
Indeed, I mean, there is
like to intervene. Yes, thank you.
Thank you, Mariusz. And indeed, there is a lot of scope for cooperation, and this is also in the name of the agency, ACER. And also there is an article devoted to cooperation in the REMIT regulation with competition authorities, financial regulators, and other relevant regulators. Having said that, there is also a line of thought that the specialization and the special character of the energy system requires this special knowledge. And this is why energy regulators are on the forefront of making sure markets are transparent and there is no manipulation. Thank you.
Keep in mind as a general principle, which I think would be true in any country or any marketplace, that your enforcement division is an extension of your policy-making apparatus. And to the extent we have at FERC in an enforcement division that is working closely with those who are developing policies, we can help further inform the marketplace of behavior that is consistent with those policies or runs afoul of those policies, with the ultimate goal being that you get a marketplace that runs as efficiently and reliably as possible.
Indeed, I think it's an important thought. We have regular discussions with the market design colleagues, discussing whether such and such market design ideas can give space for gaming behavior, or certain behaviors that we observe, how can they be traced back to market design decisions that were made in the past? So that I just repeat, indeed, it's an important aspect. Also, when I think about capacity withholding, I saw in the chat it's a difficult concept, or make-whole payments. This is probably not something that the competition authorities or financial regulators encounter in their daily work. So on the other hand, the energy regulators are very familiar with them, so they're well placed to look into those.
Daniel, that's a very good point. I like to draw analogies because usually thinking about electric markets makes my head hurt. If I take my Volvo in for service at a Lamborghini dealer, I'm sure that the Lamborghini mechanic can work on my Volvo and that it's a car. But there are differences that, while similarities, there are enough differences that I really want the expert, the Volvo mechanic, to work on my Volvo. But I wish I had a Lamborghini.
Indeed, if I may also add something here, I believe that I fully agree with everything that was said, and I believe also the added value of dealing with national regulatory authorities also facilitates the stakeholder management, because it's easier than from the NRA to reach directly the market participants or the relevant organized marketplace, exactly because of this capability of having a higher knowledge of the topic, of the market. So for us, for ACER, we truly rely on this capability of the NRA. So we focus mainly on cross-border analysis, then on main findings, let's say, or something that might be suspicious, but then we rely on the capability of the NRA to get in contact directly with the relevant market participant if it's needed, because the connection with the market, the stronger connection comes from the NRA in the end. So this is for sure an added value, and I believe it would be more difficult, let's say, if we had to rely to some other institution.
So concluding, definitely there is an added value in participation of energy regulators in the enforcement of market manipulations in various institutional models. With this, I would like thank you very much. I would like to thank all speakers and participants for your active participations and for all these questions we have received. Well, we will try to answer them as soon as possible. In the end, I would like to invite you to the next seminars devoted to market manipulations planned by ERRA. And we will ERRA will announce soon the dates of next two seminars where we will develop all these issues that were presented by our eminent speakers today. So once more, thank you very much for your participation, and I give back the floor to Kacper. Thank you.
Thank you very much. Actually, everything that should have been said was already conveyed by the moderator. So on behalf of the Secretariat, we would also like to thank, first of all, Mr. Swora for diligent moderating of this webinar, but also to all contributors from ACER, FERC, and also Swora Legal Office for today's insights into very interesting topic of market manipulation and market surveillance. As mentioned, we will organize more events on that. Please stay tuned. We will communicate regarding this very shortly. And also please stay assured that we will soon send follow-up communication regarding the recording of the webinar. And we will also try to answer all of these detailed questions that we received in the chat. Unfortunately, the agenda did not allow to address them all, but I'm sure we will have more time afterwards to go back to them and to answer them diligently. So once again, thank you so much, and have a great day and evening.
Thank you all.